Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and on behalf of Judges Bennett and McBrayer, we are pleased to welcome Mr. Harvey and Ms. Peters to this oral argument, which is being live streamed so we can fulfill our obligation to maintain our open courts. We will conduct the hearing in the same fashion as if we were all together in the Supreme Court room. Each of you has 15 minutes to argue, and the appellant has reserved some time for rebuttal. Unless there are announcements, I will ask Mr. Hibner to call the case.
Ronald Whitford et al. Versus Village Groomer and Animal Inn, Inc.
Mr. Harvey, you have the floor.
Thank you, Your Honor. I appreciate the opportunity to be before the panel. I always feel like a real lawyer when I'm at the Court of Appeals, and I guess even by technological visitation, I feel like a real lawyer again. So I'm honored to be here.
I don't think any of us imagined this when we started law school. So maybe Ms. Peters did, but not the rest of us.
Members of the panel, I have a fairly simple appellate issue, I think, before the court. I'd like to start at the end of the case and really talk about the jury verdict that was rendered. This is a case that was based upon a dispute, as sometimes happens, between two adjoining property owners. My client owned a piece of property, and next to it was another piece of commercial property, which was ultimately purchased by the Village Groomer and Animal Inn. In simple terms, our case was based upon the fact that our building on our property was showing damages that we believed was caused by the infiltration of water from the defendant Village Groomer's property. There was a vigorous 4-day trial. There was an amendment to the pleadings at the end of the proof. And ultimately there was a cause of action for nuisance and a cause of action for trespass that went to the jury. The concept or the factual basis for it was that the Village Groomer had constructed a concrete parking lot of sizable note, and they had constructed several buildings, dog walks, or pathways that were impervious to water, or less impervious, or more impervious, I suppose, than grassy fields. And I'll direct the court, at least by my oral comment, there are two documents which are exhibited, Exhibit 1 and Exhibit 14, and those are found referenced properly in the brief in the trial record. Those two documents show that after the Village Groomer bought the property, they built a large building or facility and the concrete parking lots, and they make no bones about it in the proof. They guttered it to push water toward Mr. Whitford's property. In doing so, they increased the flow of surface water, and they also redirected the flow of surface water. As promised, now going to the jury verdict form, the jury was asked in question number 1, did the defendant create a temporary nuisance? Yes or no? If you answer no, go to question 3. They answered no. Question 2 would have dealt with damages. If you go to question 3, it says, do you find that the defendant trespassed onto the plaintiff's property by diverting or rerouting water onto the plaintiff's property? And was the trespass continuing in nature while the defendant owned the property? Yes or no? They answered no, and the jury instruction said, if you answer no to question 1 and no to question 3, you're done, and the foreman should sign the form. So based upon all of the proof that we have in the record for you to consider, we think the weight of the proof indicates that the jury should have found both a temporary nuisance and a trespass.
That's not the standard that we use, is it? Isn't it? Isn't the standard whether there's any material evidence to support the jury's verdict?
Well, I think yes, but the standard we quoted in our brief, and I think when you say, is there any material evidence to support the verdict, I would say to you that we've carried that standard as well. There's no evidence that there wasn't an increase in the surface water that flowed onto my client's property. In fact, if you look at the claim at the response brief of the responding party, they attempt to argue by implication, they had the easement and they had the right by easement to put water on our property because there was a drain that existed there.
Wasn't there testimony from a defendant's expert, Mr. Bergman, that basically the water flowed the same way after Village Groomers made improvements as it did before?
Directionally, I would say there was testimony to that effect, but he clearly indicated in his cross-examination that the water had been diverted to flow in a different pattern. And the plaintiff's own factual testimony was that these buildings and drives that he had constructed were guttered, and the gutters sent the water onto my client's property. So I don't think there's any doubt that the facts would support that the water was diverted both by direction and the surface had been changed so that there was more water that was diverted.
The proof, I guess the real question is more water here, because it strikes me that the proof indicated the topography here showed that your client's property was a low point and that there was already water flowing here, and that by guttering it the way they did, with some of it going to the opposite side of Village Groomer's property, that it actually reduced the flow.
I don't think there was, I think the testimony was there were 4 new gutters coming from the building that were all pointed toward my client's property. And I think there are photographic exhibits that show that. There was just about a 5 or 6 foot span between the building site of the Village Groomer building and literally that the gutters on the other side of that building were directed to come and put water back toward my client's property. So I think all of the diversion sent all of the water with new gutters from a new building toward my client's property. And again, I think their argument is factually that they had the right to do it because they had an easement by implication to send water onto my client's property. We dispute that, of course. But
how did the water flow before? Didn't the water from Village Groomer's property already flow onto Mr. Whiteford's?
I would say to you that probably it would be true that some water would flow, but the water that flowed, my client testified, and it was undisputed, before the new buildings were erected, the water all flowed to the front toward the highway, not onto my client's property. When these gutters were put in, they directed all of the water to that 5 foot position between my client's property and that of the Village Groomer. If you think of that as a drainage ditch, I want to suggest to you, it really wasn't a drainage ditch at the time. All of the water flowed toward the highway, toward the front of each location. When the property of the Village Groomer was changed, you had water directed toward my client into that 5 foot area, and you had more of it because, as both experts acknowledged, once you take grassy area and you reduce the grassy area to concrete and roof lines, there's 0% reduction of water. There's no absorption. So it all goes that way. So you had more water and you had water directed toward my client into what was not a drainage ditch. And to further the point, the Village Groomer could have directed the water to the front of the property. Instead, they directed it directly onto my client's property. So I think I'm not trying to say that they had a duty or obligation if they were not committing these torts, but the torts that they committed were they clearly redirected the flow of surface water and the volume. They increased the volume by their improvements, and they redirected the surface water all into an area where it had not been accumulating before.
I understand that there was testimony from the people who operated Village Groomer that when they occupied Mr. Whitford's property, that there was some settling and cracking of the building that would indicate that a sinkhole was already forming underneath it.
There was testimony to that effect. They testified that there were 2 buildings. I think they were identified with the same numerical address in A and B. They were in one, not the other. The building that my client first called the investigation for was the front building, not the one they occupied, I don't believe. And they did testify that there was settling and cracking, but I don't think that that's particularly important in this issue because we never got to damages. Once the jury says no trespass, no nuisance, stop here and sign the form, they never made any damage analysis. So I don't think we can presume there was any verdict on the weight of the evidence as to a damage. My client also testified, and so did his expert, that there was a stench and a smell and an inability to use the property because of water on the property. Even if you didn't get to the issue of what caused the damage to the building, which clearly was in dispute, you still had damage from the flow of the water that had been caused by the improvements and the diversion.
Thank you, Mr. Harvey. We'll hear from you on rebuttal. Ms. Peters, you have the floor.
Thank you, Your Honor. So kind of piggybacking on the discussion that you already started, Your Honors were exactly correct in that both of these parcels of land prior to 2002 had been originally owned by one man, a Mr. Grant, and that was the evidence presented at trial. And at the time Mr. Grant owned both of them together as one parcel, there was an existing building on what would later become the Village Groomer side, and absolutely nothing developed on what would later be the Whitford side, except that Mr. Grant, for some unknown reason, because Mr. Grant did not testify at trial, had installed 2 stormwater drains on what would later be Mr. Whitford's property. And the proof was that what was later Mr. Whitford's property, because Mr. Grant ultimately subdivided it into 2 plats and sold Mr. Whitford his land in 2002, that land sits in a closed depression or basin, and that water absolutely flowed. The proof was from a south to north direction down this large hill. And in fact, Village Groomer was, slightly up the hill, and there was another commercial property, what you could say is the top of the hill, that's not a party to this action. And while Mr. Whitford did testify at trial that he tried to say the water kind of flowed across the surface in a kind of north-east direction, the proof from my clients was that when they were occupying Suite B, and the aerial maps of these properties are very helpful. The red roofed 2 buildings are Whitford's. The green roofed ones are Village Groomer. So the red roof to the left was Suite B, which was the grooming facility that my clients occupied from roughly 2003 until 2009. And the testimony was that lots of water came down that hill from where it was undeveloped at the time and pooled right there next to building B, and that a significant amount of water also came from the gutters of the muffler shop immediately to the west of Whitford's building. And on the aerial maps, that's kind of a silver roofed building. So the water pooled, and there were pictures introduced as exhibits at trial evidencing this pooling and standing water on Whitford's property right around building B, which is where the issues were ultimately discovered in 2011. So my clients purchased the building, the land next door in 2007, but they were renting from Mr. Whitford from 2002, 2003 to 2009. And all during that time, before they ever bought the property next door, they talked about doors settling. In fact, Mr. Whitford himself admitted he had to come in not once, but 2 or 3 times to recut a door that kept dropping. There was significant cracking in the walls of Suite B when my clients occupied it, to the point where you could see through walls. The gap and the cracks were so big, including seeing outside. So there was certainly material evidence that significant settling and problems were going on underneath this Suite B building almost immediately after the construction. And I would submit to your honors that this trial really came down to credibility of the parties. My clients submitted lots of photographs. In fact, pretty much all the photographs that were submitted in this case came from the defendants, evidencing the cracking and the problems with the dates to prove that it happened before the property was built next door. So let's fast forward then to when they moved next door. They bought the property, and then when Mr. Whitford terminated their lease, they constructed a second building on their property. And there were 3 gutters on this new building on the Whitford side, because obviously the opposite side, those gutters would have flowed away from Mr. Whitford's building. Of the 3 gutters on the roof side facing Mr. Whitford's property, 1 was directed away, and then 2 of them were built and channeled directly in line with the 2 existing storm drains. And
those are the storm drains, though, on the other property.
Yeah, the storm drains are created or were built on Mr. Whitford's property by the original landowner, Mr. Grant. Yes, and it was our argument at trial that at the time those were built, there were no buildings immediately surrounding the storm drains. There's no other logical explanation for why they would have existed except to capture the water flowing down the hill toward what later became Mr. Whitford's property and then taking it away. And in fact, at trial, Mr. Whitford's own expert, Mr. Neely, said that by channeling and diverting those 2 gutters to the storm drains, that was actually a more desirable situation than letting it disperse across the ground, because obviously this karst formation under Mr. Whitford's property, does not recognize, subterranean property lines. So really any water percolating into the ground anywhere in the vicinity of Mr. Whitford's property could potentially work its way down through the soil subterranean and get down to this karst formation. So he said it actually helped for this water to be funneled more directly to the drain so it could be taken out and not percolate into the soil anywhere right around Mr. Whitford's property. And that can be found in volume 12, page 366. And you were absolutely right earlier in stating that our expert, Mr. Bergman, ultimately testified that there was no measurable increase in any kind of surface water before versus after the construction of this new building on my client's property. Because again, it was on a hill, so the water was always flowing down the hill from my client's property toward Whitford's, just by nature of the topography of this area. And in fact, because the roof directed half of this water away, and they funneled 1 of the gutters away, and the other 2 were funneled directly to spill into the storm drain, for which we argued we had an easement to do because the properties were originally connected, and the case law says that if that's the case, you can continue using it for the purpose of which it was originally constructed. That it actually resulted in a net decrease to the water going onto Whitford's property.
What was the testimony about the odors that were?
There was actually very little testimony, but it did come in. Mr. Whitford took the stand and said that he did not like the dog runs that had been built on my client's property, and that he felt that there was an unpleasant stench. There was no other testimony regarding that issue other than Mr. Whitford. I think that briefly their client, their expert, Mr. Neely, as I recall, was asked about that. And he just generally said, well, you know, you're working between two dog kennels. So yeah, it didn't smell great, but he could not differentiate one versus the other. Then there was
he didn't blame one over the other then.
He did not. And then there, of course, was testimony from my client that his dog runs for Village Groomer it was like astroturf or fake grass. And then, so any, you know, urine or whatnot from the dogs would go through that and down into this channel that was built to handle that. And they had shampooers that they used daily and would hose it down. Whereas on the village, on the Whitford side, they just had a side yard that they let the animals go out into. So there's really no way to clean that. They would just urinate on the grass in the side yard. So there, again, I think that's just the jury had to make a credibility determination about whether they felt there was a nuisance because of the smell. And obviously they decided that there was not. Now, on the jury instructions on this case, they were instructed that a nuisance is an unreasonable or unlawful use of property that results in material or substantial harm or injury to the plaintiff. And that really seemed to be what they latched onto in their deliberations. Later on, under causation or legal cause, they also were instructed that the conduct must have been a substantial factor in bringing about the harm being complained of. And that's just the pattern jury instructions for nuisance and then legal cause. The sole question the jury brought back while they were deliberating was asking the court to define substantial cause. And after discussing it with the attorneys, it was agreed that the court would just reply, you need to apply its ordinary meaning. And so they deliberated for some time longer. I believe it was a little over 2 hours total, and came back and clearly ultimately found that there was no substantial or material harm or injury to the plaintiff. And if that's the case, you cannot have a nuisance. That's part of the definition. So with regard to trespassing, it was interesting because that wasn't a part of the lawsuit for the 7 years we litigated it. And after the close of proof that was added, the complaint was allowed to be amended. But the court did allow the special jury instruction regarding the easement, and there was absolutely no evidence to rebut that Mr. Grant put that in. That was agreed to by the plaintiff in his testimony. And he also agreed that the drains appeared to be working properly, because in fact, the plaintiff, Mr. Whitford, had to repair the drains after he took ownership of the property. So it was his understanding that they were working properly and diverting water as they were intended to do.
There's no evidence that the drains were, overwhelmed or stopped
Correct.
up or anything.
That's correct. That he was specifically asked that if there was any problem or that water would come out, and the answer was no. The testimony was that at some point after he took possession of the property, the state or some governmental entity had come in to do work along the highway that neighbors these commercial properties, and they had crimped the line or something where it terminated, and so that it had to be repaired because of that. But no, there was no testimony that at any point were the drains ever overwhelmed or couldn't handle the water.
Thank you.
Thank you.
Anything further, Ms. Peters?
No, Your Honors. I think that handles everything. You saw in the briefs that, I would just add one additional thing, that part of the problem, I think, with the plaintiff's case at trial was that their expert never could differentiate between the different sources or causes of the problem, the karst formation and what caused the sinkhole. And he lumped the existing Village Groomer building into his analysis. And the problem with that is that pre-existed Mr. Whitford building his buildings. And so that was, he considered his testimony was Village Groomer as a whole caused this harm, but that part of it cannot be actionable. And then he also testified that his biggest concern about the Village Groomer property was these dog runs, because they thought all this water hosing them down every day was being funneled onto Whitford's property, when in fact the testimony actually ended up being that none of that water got diverted off of my client's property. It went straight down into the ground, because the funnels that they thought were coming from the dog runs, that was actually a funnel for one of the gutters. And so it was not substantiated at trial.
All
Thank
right.
you.
Thank you, Ms. Peters. Mr. Harvey, your rebuttal.
Thank you. I want to speak directly to the question Judge Bennett asked last. The reason the existing drain, which predated all the construction of the Village Groomer improvements, was not overrun is because the water that was thrown into the 5-foot ditch went back to the back of the property. One of the gutters, sure enough, was these gutters, as you can see from the photographs, were elevated about 4 foot above the ditch and pointed directly toward my client's property 5 feet away. One of them was pointed, sure enough, toward the drain where it had been located, but the water would fall in the ditch and run back away from the highway. This ditch was not a drainage ditch. As I said earlier, if you called it a drainage ditch, it would really be inappropriate, because the water drained across to the highway. What's truly and clearly happened here is the responding party is trying to say, well, we were putting water over on you, but it's okay because we have a drain there that was meant to take this water. They're trying to say to you, well, we didn't funnel all of our water from these improvements into that ditch area. But the answer is, I think, yes, they did. I think a careful review of this will show they had their air conditioning water drainage thrown into this ditch area toward my client. I think they had 4 gutters, including those on the other side of the building, that were directed and piped to come toward my client's property. And I think a careful reading will show that Mr. Neely did say that the water coming from the Village Groomer property on the surface was a substantial factor in bringing about the harm, in his opinion. Now, the jury never got to that question. I think if you look at a liability issue on this case, you have to say the jury said no nuisance and no trespass, despite the fact that there was material evidence that additional water was flowing onto the property, that it was flowing in a new direction. It had been directed there by these gutters, and that it was coming onto my client's property, arguably causing a stench and a smell and an inability for him to use his dog walking area there in the front. I think if you start looking carefully at what proof was presented, you'll see there's no real discussion about what that original drain had to do with anything. It was there before my client built on his property. I think if you look carefully at the case law, the facts that were presented in the case, the 2 buildings that were on my client's property were both owned and constructed by my client, one of them rented by the Village Groomer for a period of time. The extent of damage or the causation of damage to the building was never reached by the jury. We have a question here, which I think in its simplicity is, if the facts have shown material evidence that more water and additional directional activity of water was made, then isn't that a trespass? Isn't that a nuisance? And if it is, then it needs to be sent back so that we can go, frankly, win or lose that causation issue on the damage. Did it cause the building to collapse or fall? Did it cause the building to sink? But at this point, I think we clearly had established both the temporary nuisance and the trespass, and the jury simply stopped too soon. I'll also suggest to you that a careful reading will show that Mr. Neely testified as soon as he arrived at the property, he could see that there was substantial water having been diverted onto the property from the improvements. And I think when counsel says no one testified about the stench except Dr. Whitford, but then Mr. Neely did testify somewhat. I think he did testify that there was a stench there. I think that he testified he thought it was coming from this drained dog run. And his first recommendation was to try to find some way to ameliorate the problem of surface water coming onto my client's property, and the village groomer would have none of it. And that testimony is in the record. They committed a trespass and they maintained a nuisance on the property. Thank you. I appreciate that.
Thank you, Mr. Harvey and Ms. Peters, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 11 a.m.
Counsel, you're free to exit the meeting.